got it. Okay. So the International Court of Justice is also called the World Court, is the main judicial organ of the United Nations. It has its seat in The Hague in the Netherlands at the Peace Palace, and it is the only one of the 6 official organs of the United Nations that is not located in New York. All the other organs of the United Nations, like the Security Council, the General Assembly, the Economic and Social Council, the Trusteeship Council, and the Secretariat, are located in the United States. The Court of Justice is located in the Netherlands, and in fact, its 2 main official languages are French and English. So what does it do? It has a contentious function, which means that it settles legal disputes submitted to it by the states in accordance with international law, and it has an advisory function, which means that it gives opinions and advice on legal questions that have been referred to it by authorized UN organs and agencies. And so how do these procedures work? So the contentious cases, basically the competence of the court is only restricted to those states who have accepted its jurisdiction, either when they submitted the case to the court or when they have signed beforehand an international agreement that said that they would yield their competence to the court. And after the trial procedure, the court will emit a sentence that cannot be appealed. And in fact, if a party fails to comply with the decision of the court, the other party can make recourse to the Security Council. So states are not obligated to yield to give jurisdiction to the International Court of Justice, but once they do, and the Court of Justice has emitted a sentence, it cannot be disobeyed. So typical judgments of the Court of Justice are made on topics like land frontiers, maritime borders, territorial sovereignty, the non-use of force, violation of international and humanitarian law. You kind of get it. It's mostly international topics of international law and then concern international politics. Meanwhile, advisory opinions, well, as I've said, only the 5 main organs of the United Nations and its 16 agencies may ask the ICJ for opinions, which are not binding. So now we go over to a little bit of historical development. As I said, I'll be quick. So the first precedent of the Court of Justice is the Hague Peace Conference of 1899, where smaller states of Europe, Asian states, and Mexico participated, and their objective was that of discussing peace and disarmament. And so they created the Permanent Court of Arbitration, or PCA, which really wasn't that permanent because it was only an institution that provided a framework for setting up kind of independent arbitration tribunals when necessary. So when 2 states had a dispute, they would just set up these tribunals through the Permanent Court of Arbitration that would rule on their case. And this permanent court began operating in 1902. And so then we have in 1907 the Second Hague Peace Conference, in which also participated states of Central and South America. So in this conference, the United States wanted to institute a permanent court with the judges who would work full-time on the court, but the conference never came to an agreement on the method of election of the judges, and so the project never moved forward. And this was a problem because, in fact, in 1913, as time passed, it started to become evident that the independent tribunals set up, when necessary, would not give a cohesive interpretation of international law. So the states wanted a court that was permanent, that would give kind of a coherent ruling on all matters of international law, and that wasn't happening with the PCA. And so in 1920, after World War I, the League of Nations gave its council the task of formulating a statute of a Permanent Court of International Justice, or PCIJ, which would have both a contentious and an advisory function, exactly like the International Court of Justice today. So after a long process, the statute was finally adopted in December 1920, thanks to a unanimous assembly vote. And the statute also established a procedure for the election of the judges, which was the main point of conflict between the states at the Second Hague Peace Conference. and was basically the main problem, which did not make the institution of a permanent tribunal possible. So now the states finally reached kind of an agreement on how judges would be elected. And so in 1922, the rules of the court were drafted, and a judicial procedure was established for the court, which started its function, and between 1922 and 1940 ruled on 29 cases total and issued 27 advisory opinions. So let's go on. So in 1939, with the outbreak of World War II, the court's business decreased, and it stopped officially working on the 4th of December 1940, when it delivered its last opinion. However, after World War II, many countries agreed on the importance of an international court of arbitration, which would help solve international disputes. And so at the San Francisco Conference of 1945, which was the conference that was designed to draw up the United Nations Charter, a committee of 44 states submitted a new statute for the next Court of Justice that was based on the statute of the Permanent Court of International Justice. And so the 50 states present at the San Francisco Conference decided to create a new court that would be the main judicial organ of the United Nations. And so in 1946, we have the first ICJ meeting. So in April 1946, the Permanent Court of International Justice was officially dissolved, and the ICJ took its place and held its first inaugural public sitting in the Hague Peace Palace. And then in 1947, we finally have the first case of the ICJ, which was concerning incidents on the Corfu Channel and was brought by the United Kingdom of Great Britain versus Albania. So after this, we have the members of the ICJ. So the members of the ICJ are the judges of the ICJ. The ICJ has 15 permanent judges that serve 9-year terms. So 1/3 of the court is elected every 3 years, and there is the possibility of re-election. And to be elected, a judge must get the absolute majority of votes in both the Security Council and the General Assembly. So the Security Council and the General Assembly vote separately, but on the same day, and they both must vote with an absolute majority in favor of the judge being elected. So the states can propose the candidates for election to the court, and there cannot be more than 2 judges from the same state on the court. And once elected, the judge does not represent his or her country, but is an independent official, and they must exercise their powers impartially. And the court selects a president every 3 years. So the court has a president, which does not really mean anything because his role is mostly administrative, and he only directs the court's activities. And the vice president also has a the president also has a vice president who replaces him or her in case of their absence. So now we have finished with the historical background part, and I will yield the floor to Vittorio, who will explain the protocol of the simulation.
Okay, thank you, Ginevra. And now we are going we're going to discuss about the most ICJ simulation part. It is about the rules, the protocol, and who are the main actors of ICJ simulation. So, and who take part in the ICJ? There are, first of all, the president and the registrar, who are actually, let's say, like the chair in model United Nations simulations. In fact, the judge is not the judge, sorry. The president is the person who accepts and rejects objections done by advocates, and they are in general those who are actually administrating the simulation. Secondly, there are judges who are usually about 20, but could be even less in our simulation. And judges are those who actually decide which one of the 2 parties has the victory and wins the trial. They do so by asking questions to advocates, by listening most of all to the evidence, and also by applying the power, which consists of discussing all together about what has been said by the advocates, and then decide which one has convinced them. The winner is chosen by a majority. 50% plus one is the winner. But usually it would be better to have a strong majority. This is because the president can apply his veto power to judges' decisions. This means that judges, if what decided by judges does not fully convince the president, then he can decide to simply make a new votations, a new procedure, and to reanalyze the evidence given by the advocates. Then, obviously, advocates are 3 for each team, and 3 for plaintiff and 3 for defense, depends on the case, who is representing who, but these are the two parties usually. And their unique scope is to make sure that judges are convinced that what they are saying is right. So they have to convince judges of what they are saying so that they will then accept the evidence and give them the victory of the trial. Finally, we have witnesses who are 1 for each team usually, but could be even more if we have more time. Anyway, witnesses are simply some people who advocates call to support their positions. Witnesses usually are some people who have actually particular skills or who were actually personally involved in the trial or in what happened that brought to the trial. Well, okay, let's go. So here you can see a small representation of the trial. We have in the first part the opening statement, then the presentation of the evidence, witness examination, closing statement, and deliberation. We're going to discuss them right now. So the opening statement is a short discussion about the case done by both teams, separately, obviously. Each team will have 10 minutes to express their position about the topic discussed in the trial. This means that they will not absolutely give any detail about their evidence or what they will bring to the attention of judges, but they will simply discuss and introduce the trial to the court of the judges. Secondly, there's the presentation of the evidence. As you can see, the time for presentation of evidence is much longer than the opening statement. This is because the presentation of the evidence has to be really detailed. Advocates will bring to attention of judges every single paragraph, every single article of their evidence. Since evidence is usually quite long, you will have some days to prepare it, about even months if we can. They have a lot of time to introduce it. After this, the other team will have a shorter time, about 5 minutes, to bring to the attention of judges what was not convincing about the other team's presentation of the evidence, and point out what were the mistakes, in their opinion, given by other advocates. At the end of this moment, we will have a short session of questions done by the judges. Judges will ask each team of advocates some clarifications or some questions they might came to their mind. And during the answers of advocates, the other teams can do objections. We are going to discuss about this topic later more in detail, because I know that it is the most interesting one, as it is actually where the debate takes place, as we are all used to watch movies where during trials people really fight and argue, even insult each other. This happens usually in this moment, which means after the presentation of the evidence during the extraordinary session of questions asked by the judges. Then we have the evidence. So as I said before, shortly, the evidence consists of all the different articles, paragraph, and data that would prove that the idea presented by one of the two teams is the correct one, and so it should be supported by judges. And evidence is, as I said before, quite long usually. And evidence can even be about 30 pages. This is why we usually give a lot of time to prepare it. For example, when I did last time ICJ, it took me 2 months to prepare my evidence. But this should not scare you guys, because it is really, really fun to do it. And most of all, you will not be alone, as you will have two teammates as advocates who will help you prepare this evidence. And most of all, you will have the support of the two presidents, me and Ginevra, who will absolutely give as much help as possible to you guys. And though you have to pay a lot of attention, because your evidence may be even invalid. This happens when the evidence is not encountering the standards required for respect of plagiarism and other things like that. You must not copy, guys, absolutely not. If you copy, you must put your sources, because before the trial, the judges, and together with the president, are going to analyze really article by article all the evidence points with the sources you provide in the bibliography. So this is a really important thing, guys, that you must not copy, because we have to find something new, we have to have fun, and if we copy, there's no longer fun, obviously. And there's also an objection about copying data taken from somebody else, and we will discuss about this later. So another part where really we have important fights, really even bloody fights, is the witness examination. We have 15 minutes where each team will present his own witness. The interrogation of the witness is done by the advocate who brings him or her, obviously, but it could also be carried out by all the elements of the team. After this 15 minutes of questions, we have the counter interrogation done by the other team of advocates, which is quite shorter, but it has the aim of putting into really danger the other team. It is important for the witness not to be put into contradiction by the counter interrogation. In fact, if the other advocate manages to give serious difficulties to witnesses, then it is really likely for judges to have a little bit of less belief in what the witness said. They may in fact be often like driven not to really take care and understand and consider really what the witness has been saying. You must show really self-confidence, just like your witness has to do. And after that, also the judges will have the opportunity to ask questions to the witness. And in this moment of the trial is really the most bloody one, I would say, because in this moment we have the highest number of objections and the highest number of even insults through the parts. This will then reach its zenith at the debate, as the debate is the moment where actually the two parts answer questions asked by the judges, and these questions are really leading to some problems if they're not given a really good answer. In fact, if one of the two parties is not able to answer a question asked by the judges, or is it even worse, put into difficulty by a question asked by the other advocates, the other team of advocates, then in that case, really problems come up, as it would be really either humiliating to be defeated and destroyed so clearly and so in a violent way by the other team. So it is important. This is probably the most important part of the debate, of the trial in general, because the debate is the moment when we find the highest number of opportunities to either sustain your ideas or to make the others sustain theirs. The most important thing, even more than making, put into account, and even more than pointing out your ideas, is to point out the errors in the other team's evidence, which is the reasons, which means that in this moment, moment of the trial, we can really demonstrate what is wrong with the other team's evidence and ideas. Then at the end, we have the closing statement, where no objections can be made by neither of the two parties. So the closing statement is, in practice, the moment where two teams recap what has been said during the trial, where they point out to the judges what are, in their opinion, the most important key factors of their evidence, and what are instead the weakest even parts of the other team's evidence. As I said, in this part, we cannot do any objection. This is because everything has already been stated before. So it is more likely for them to have already denied and to have already pointed out what is in there. Although there's an advantage for one of the two teams. Usually the statements are done before by the plaintiff and then by the defense. The defense in here has a really important advantage. They can, in fact, point out during their closing statement what is wrong about the closing statement of the plaintiff. This means that they can, during the closing statement, instead of supporting their ideas, they can instead really throw mud towards the other team's closing statement, which cannot be done by the plaintiff who presented before, because obviously presenting before, they do not know what the other teams is going to say. They could only imagine. Then finally, we have the deliberation where advocates are not going to be there. It's secret, the deliberation, only between judges and the presidents. It has no time limit, and it has it consists of the review of all the evidence, all what has happened during the trial by the judge and the judges and the presidents. As I said before, the winner of the trial is the one who manages to get at least 50% plus one of the votes of judges and presidents. And though if the verdict does not satisfy the presidents, then the two presidents can decide together to use their veto power. So this is how the trial takes place. I know it's quite complicated, as I said. Now it seems difficult, but actually there are no really procedures to be learned. In fact, everything is going to be driven by the judge, the judges, but even more by the president, who is the one who accepts and the one who decides when it's the moment to pass to a new part of the trial. Really, the only thing advocates need to learn are objections, which are here scheduled. I suggest you guys to take a screenshot of these objections, because you really have to know them. It's the only thing you have to know for the ICJ. There's no motional procedure established to open a speakers list. No, there are only the objections. And anyway, the moment when objections can be done or not are anyway going to be reminded by the president and the presidents during the session of the trial. So don't worry even to remember exactly the moment when you can make your objections or the timing of each different part of the trial. Nothing about that, just objections, but these really are important. So these are the five different objections we can find in an ICJ simulation. So first of all, and the most famous one, the most popular one, the one that will always come up is speculation. So speculation comes up when there's something that has been said by one of the two parties or a witness that, though has not the value of some data that's supporting it, but it is instead simply an opinion of an advocate, for example. This cannot absolutely be done in an ICJ trial. In fact, everything that has been said by advocates has to be supported by trials, and advocates are not asked, neither able to give their own position about a topic. For example, if we are discussing about air pollution, and I am an advocate against the use of green energies, I'm not allowed to say that, in my opinion, green energy sucks, because it is not, and there are no evidence providing this, and it is my personal opinion, and I cannot absolutely say my personal opinion. Then, secondly, reliability. So it is used when mainly with witnesses, actually, but also with advocates. And it is used when there's a suspect of plagiarism, which means that the source from which certain data or certain knowledge has been taken is not clarified or it's not indicated. As I said before, in your evidence, you always have to write everything every single website or book from which you take your data and your evidence anyway. Then relevance, it's quite similar to speculation in some situations, and it is used when an advocate speaks about something that it's not relevant with the case. For example, talking about air pollution, I cannot start talking about football, for example, which is not relevant, obviously. Obviously, this is a stupid example, but during a trial, it might happen that there's something absolutely irrelevant, which really deserves this kind of objection. Then hearsay. This is also, just like reliability, used mainly with witnesses. Hearsay is an objection that is used to point out the fact that a witness cannot say something that has been said by somebody else. For example, if the witness of the plaintiff is, I don't know, Berlusconi, and the witness of the defense is Prodi, Berlusconi cannot say something said by Prodi. Berlusconi has to say only something said by Berlusconi or something said by scientists or anyway some sources that Berlusconi is going to say anyway to state. Then the last one, leading question, and this one is used usually during the counter-interrogation of the witness. In fact, the aim of counter-interrogation is to bring difficulties to the witness and bring him in contradiction. Leading questions, therefore, are often used by advocates to give problems to the other party's witness. If the witness party realizes that the advocate is asking a leading question, then they may use this objection, and the president is going to ask the advocate of the counter interrogation to reformulate his question in order not to have a leading question. I have finished. If you have any questions, guys, please ask. It's simply, we are here for this.
Yeah, guys, we thank you for your attention, and really, if you have any question, either type them in the chat or yes, Ali.
Okay, so basically, he said that you guys said that we can not copy evidence from somewhere else. So, like in a conference or in a model ICJ conference, do we have to create an evidence by ourselves? Like, what's the procedure? How is an evidence how does an evidence need to be created? Like, that's the part where I was confused.
Yes. So yes, actually, I may have explained myself better, I realized. So when I said that you cannot copy, I meant that you cannot simply take paragraphs from some reports or anyway articles you find online and simply copy and paste. This cannot be done. This does not though mean that you can't use data found online. This is not absolutely true. You have to use data. But these have to be data coming from really famous sources or short sources of information. Obviously, if you really can't paraphrase what you find online, we are not going to make your evidence invalid for this. But please, if this happens for like a few sentences, but if you simply copy and paste the entire evidence, this is not good. You can't do this. That's why I said you can't copy. Yeah. And tell me if I answered, and I hope so.
Okay, I understand that part, but like I have another question, and that was regarding the witnesses. Like, it makes sense. Like, one party has a witness in like a real life case in ICJ, but like when we are representing one side, like a group of 3 advocates, who exactly will be our witnesses in the model ICJ session?
Actually, I said we have one witness because in this situation with online sessions, it's going to be much more difficult to have long sessions. You know, attention of people after a while becomes even always fewer and smaller. So we are going to have shorter and few sessions, which means that we are going to have the time just for one single witness, I suppose, which is going to be prepared by the entire team. In fact, usually in model ICJ sessions and trials, we have 3 different witnesses, one for each advocate of each team. So we have in total 6 witnesses. But obviously, in this situation with online sessions, it's really difficult to have many sessions and many even interesting sessions. So that's why I said just one witness. I hope we are going to have even more time to have maybe 2 witnesses for team, but I think that for the moment we will have just one witness per team, prepared by the whole members, obviously, of the plaintiff and the whole members of the defense. So 2 witnesses in total.
If I can ask, basically the witnesses are normal people, like maybe someone who is an MUN, someone who participates in MUN, who is in MILMUN and wants to be a witness. The advocates can go to this person and say, look, you have to know this and this and this and this. And they prepare their witness and then bring them or her to the trial. So it doesn't have to be any like a public figure or anyone, just a normal person that will be prepared by the team. I hope that answers.
It's one of us.
Okay,
Yeah.
I get it. Thank you.
Yeah.
Then my suggestion when you're going to choose witnesses is to find somebody who has a minimum of self-confidence, because choosing a really shy person might be even dangerous for your trial, because it might be brought in serious damage to your team, mainly during the counter example. The counter. Yeah, it's late, guys. Mainly during the counter interrogation of the other team. So you have other questions, guys?
Yes.
Yeah, Millie. Yeah.
Melissa?
Hey, thank you for the presentation first. And so my question was, do you know when this is going to be held? And secondly, do you have any examples of like the most recent case that was debated at the ICJ?
Okay, so as for when it's going to be held, we do not know. We hope that we have been discussing it with Margot and all the other chairs at MILMUN, but we still haven't got like a definitive date. We hope sometime in December, but we don't know because we are also planning like more structured MUN conferences. So yeah, we still don't know an exact date. We hope it's going to be in December. And as for the case, the most recent one, I do not know. I'm going to be honest. I do not know which one is the most recent one of the ICJ. Wait, maybe I can find it very quickly.
No, don't worry. It was just in case, by curiosity.
Oh no, I'm sorry. You caught me unprepared there.
Anyway, the topic we're going to choose is probably going to be one of the most recent ICJ trials.
That's what we're discussing. We probably for our simulation are going to be choosing like maybe even the most recent one, which is still open. That in that way, like the advocates will not have kind of all the work, already there. They will have to kind of be prepared. So yeah, I'm sorry, I can answer your question on that front. But
I found it actually. Okay. Here it says that the last trial done by ICJ, it's about Birmania. I don't know about what or why, but it's about Birmania, the Asian country.
So if that's still open, that's probably the one that we're going to choose for a simulation, and then we'll let you know like all the details.
Okay, great. Thank you so much.
Oh, thank you.
You're welcome.
Anyone else has any questions?
Hey guys.
If not, yeah, please.
Awesome. So it's not a question. I just wanted to congratulate you. You did an amazing work. I really liked your presentation. Very helpful, very informative. Yeah, you guys did an awesome work. I just wanted to say, so for when will the actual ICJ take place? The thing is that we don't really know because you guys have been pretty busy right now. So not only for the workshops, but also in the different departments with the newsletter, with the social media, with our weekly sessions. And we didn't really want to overload you guys. And also the point that in December we're going to have the exams that are coming up. So, for all these reasons, we didn't really know what date to fix for now, but of course we'll let you guys know exactly. But yeah, thanks again for the presentation, guys. It was amazing.
Thank you, guys. Yeah, we're gonna upload this to the group chat. So yeah, you can find it there, and then we have the recordings. So I don't know, I think we'll upload them somewhere, but they're here if anyone needs them.
And I just wanted to say something. I know it might seem at least scary, the procedure I've tried to summarize today, but we are planning and trying to organize a kind of mock model ICJ session just to show you guys how it works. And with me, another friend of mine who has taken part in ICJ, and Ginevra, if she wants to, and others. We are we're going to try to do so.
So yeah, we hope to see you in the future, and thank you so much for coming today. We really appreciate it. And yeah, we won't keep you anymore. You guys can go. Thanks a lot.
Thanks for the presentation.
Thank you.
Nice evening.
Have a good evening.
Bye, everyone.
Good evening.
Bye, guys. See you in ICJ.